Hi, thank you for joining us today for a presentation on getting off to a good start, strategies for startup companies to identify, protect, and defend their intellectual property. We work for the law firm of Snell and Wilmerr, which is a large general practice firm with over 9 offices throughout the Southwest, including Tucson, Phoenix, Denver, Las Vegas, Los Angeles, Los Cabos, Orange County, Reno, and Salt Lake City. We have over 30 intellectual property attorneys, most of whom are here in Arizona. All of our attorneys have a hybrid practice, which includes assisting clients with procurement, enforcement, and technology transfer. My name is Cindy Pilati, and I'm an intellectual property attorney at the firm of Snell and Wilmerr. My practice focuses on working with clients to develop, implement, and manage strategies for procuring, maintaining, and enforcing their intellectual property rights. I work with several startup companies to develop patent, trademark, and copyright portfolios and help clients license and transfer their intellectual property, as well as develop practices to avoid infringement of others' intellectual property. My clients work in a variety of technology areas, including nanotechnology, medical devices, green technologies, semiconductors, and others.
Now, Bill's practice is concentrated in intellectual property law, including patent, copyright, and trademark licensing, litigation, and procurement. His past experience includes serving as in-house counsel for pharmaceutical and agribusiness-based industries. A substantial portion of Bill's practice involves strategic counseling for these industries, including all IP related aspects of discovery, development, and commercialization activities. Bill has extensive transactional experience and has successfully negotiated a wide range of licenses and other agreements in support of various industry and university alliances. His patent procurement practice includes comprehensive life cycle management planning from emerging technologies to post-patent expiry of commercial products. And Bill's life science practice includes small molecule chemistry and biologic therapeutics, as well as diagnostics, drug discovery, and delivery. Finally, his agribusiness practice similarly focuses on chemical and biologic-based active ingredients, as well as formulation and chemical process technologies. Bill's practice also includes U.S. interferences and European oppositions, as well as matters before the USPTO, Board of Appeals, the federal courts. Prior to joining Snell and Wilmerr, Bill was part of a litigation team that obtained a patent infringement jury verdict of $49 million and findings of non-infringement on multiple patent claims brought by the defendant. Bill's practice also includes U.S. interferences and European oppositions, as well as matters before the USPTO, Board of Appeals, and the federal courts. Prior to joining Snell and Wilmerr, Bill was part of a litigation team that obtained a patent infringement jury verdict of $49 million and findings of non-infringement on multiple patent claims brought by the defendant. And I'm Eric Nielsen. My practice is centered on intellectual property counseling, in particular the design and implementation of business-driven strategies to identify, protect, defend, enforce, and otherwise build value in IP assets, including patents, trademarks, copyrights, and trade secrets. I have experience in virtually all facets of IP law, including patent and trademark prosecution, U.S. as well as foreign, proceedings before the Board of Patent Appeals and Interferences and the Trademark Trial and Appeal Board, clearance searching and invalidity and non-infringement opinion work, patentability searching and trademark screening, IP dispute resolution and litigation, IP licensing and other diverse agreements and business-driven transactions having IP components. I've worked with clients ranging from sole inventors, emerging growth companies, and those seeking angel investing and venture capital to Fortune 500 companies. I have technical expertise in, among other fields, bioengineering, medical devices, pharmaceuticals, mechanical devices, green technologies, nanotechnology, a variety of consumer products, as well as business methods.
Our objectives for this workshop are to provide you with an overview of intellectual property law including a discussion of what can be protected using patents, trade secrets, trademarks, and copyrights. In addition, we hope to provide you the tools to enable you to create your own plan to identify and protect your intellectual property. Finally, we hope to provide some tools to avoid the thicket of others' intellectual property. That is, to avoid infringement of third-party intellectual property. More particularly, we hope to provide you with a basic understanding of intellectual property law that you can use to add value to your company by identifying your intellectual property, which may include an understanding of others' intellectual property so that you can understand the likely scope and breadth of your rights, by protecting your valuable intellectual property, often from multiple directions. This includes parsing out the wheat from the chaff and focusing your resources on important or valuable intellectual property, and by steering clear of third-party intellectual property by understanding the rights of others and likely scope of those rights.
So let's begin with the working definition for intellectual property and the rights associated with intellectual property. Intellectual property includes tangible and intangible ideas, information, and things that are created or derived and that have a commercial value. Intellectual property rights are bestowed on the owners of ideas, inventions, and creative expression that have the status of property and, like tangible property, give the owner the right to exclude others from access to or use of their property. Now, importantly, intellectual property rights do not give the owner the right to practice ideas, inventions, or creative expressions. Put another way, for example, a patent or a copyright owner could very well still be sued for using the technology or artwork embodied in his or her patent or copyright.
Intellectual property rights can be used as an offensive weapon, a defensive shield, and as a corporate asset. In the offensive sense, you can use your rights to sue for damages, to collect revenue from those using your IP without your permission, to sue for injunctions so that you can stop others from making, selling, or using products or services that embody your intellectual property. And often ownership of IP itself is a deterrent to others, as we'll talk about later. And often ownership of IP itself is a deterrent to others. As we'll talk about later, when you do a search and uncover, for example, a patent or patent application, you may be inclined to avoid infringement or possible infringement of that IP. The same is true for your competitors. In the defensive sense, you may use your IP to prevent others from obtaining a monopoly in the area. For example, another company may have a patent that covers your product, and you may have a patent that covers their product. In this case, you can use your patent as a shield against an assertion of the other company's patent against you. Additionally, you can use your patent in a defensive manner to set up motivation for another company to license technology that you may need to run your business.
And to further underscore the increasing importance of identifying and protecting intellectual property, Ocean Tomoe recently distinguished tangible and intangible assets of the Standard & Poor's 500. 80% of the 2010 market value was found to be attributed to intangible assets, compared to only 17% of the 1975 market value, a 63% change.
As we noted above, for young companies, IP is often your only asset and the only thing you have to offer in return for an investment. In addition, understanding others' IP is important because it helps you understand the scope of your protection or possible scope of protection that you may obtain. It may help prevent you being sued by others for infringing their IP, and it helps you and your investors better understand the value of your IP by understanding what others have protected in addition to understanding what you may be able to protect.
There are 4 primary areas of intellectual property, namely patents, trade secrets, trademarks, and copyrights. To help you understand the scope of each area, we can look to some of Koch's intellectual property. First, patents protect inventions. Consider, for example, the utilitarian configuration of a Coke can that provides for its optimal stacking, crushing, material conservation, and ease of manufacturing. Next, trade secrets protect secret information, including secret inventions. You might think of the Coke recipe developed in 1886 by the pharmacist Dr. John Pemberton, perhaps one of the most famous trade secrets. Next, trademarks protect source identifiers. The Coca-Cola name is a classic trademark. And finally, copyrights protect original works of authorship. You might think of the creative expression embodied by a Coke commercial that is aired during the Super Bowl. So patents afford inventors a legal right to exclude others from making, using, selling, importing, or offering to sell a patented invention. As I mentioned earlier, this is not a right to make, use, sell, import, or offer to sell. Patents serve an important public policy, which is to advance innovation through full disclosure of the details of the invention to the public. And in exchange, exclusive rights are granted for a term. Now, the standards for patentability are high and can be seen as being fourfold. To be patentable, an invention must 1, be useful, 2, novel, 3, non-obvious, and 4, the inventor or inventors must be willing to fully disclose the invention to the public. Now, usefulness is generally a relatively easy hurdle to overcome, as can be novelty, the latter meaning that the invention cannot be disclosed in a single prior art reference. Inventors are generally familiar with what others are doing and have previously done in their fields, and they don't spend time reinventing the wheel, so to speak. On the other hand, non-obviousness is sometimes difficult. It's a difficult standard to meet. Non-obvious means that the invention cannot be disclosed in multiple prior art references when combined. So in other words, an examiner at the United States Patent and Trademark Office may look to multiple prior art references that may even appear to be somewhat unrelated in finding an idea unpatentable. Now, in terms of disclosing the invention to the public, a patent application must include a written description that both 1, enables a person skilled in the art to which the invention pertains to practice the invention, and 2, includes the best mode contemplated by the inventor or inventors for practicing the invention. So you might ask, what is patentable? Well, there was a 1980 Supreme Court case called Diamond v. Chakrabarty, and it was held that anything under the sun that is made by man is patentable. So this includes machines and devices, processes, methods of manufacture, compositions of matter, business methods, non-functional ornamental designs, and additionally, though less common, asexually reproduced, distinct and new varieties of plants. By contrast, the laws of nature, physical phenomena, and abstract ideas are not patentable subject matter. So a new mineral discovered in the earth or a new plant found in the wild is not patentable. Likewise, Einstein could not have patented his celebrated E equals mc squared, nor could Newton have patented the law of gravity. Such discoveries are mere manifestations of nature, and they should be regarded as free to all and reserved exclusively to none. Now, if ultimately obtained, a patent is enforceable as of the issue date, and the term of a patent is 20 years from the earliest claimed priority date. Turning now to trade secrets, a trade secret generally means information including a formula, pattern, compilation, program, device, method, technique, or process that does 2 things. 1, it derives independent economic value, whether actual or potential, from not being generally known and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use. And 2, information needs to be the subject of efforts that are reasonable under the circumstances to maintain its secrecy. And like patents, and as I mentioned earlier, trade secrets are exclusionary rights. A trade secret's owner has the right to prevent the unauthorized use or disclosure of trade secret information, but only by a person or company who acquired the information through improper means. Trade secret misappropriation often arises in the context of an employee leaving to work for a competitor, or a competitor engaging, for example, in economic espionage of some sort. But there is no trade secret misappropriation, on the other hand, if the information was independently created or if it was acquired through lawful means, for example, reverse engineering, or the owner's own inadvertent disclosure of the trade secret information. Unlike patents, there's no term for trade secrets. They subsist as long as the owner successfully prevents them from becoming widely known, which is a great advantage over patents. Like patents, the breadth of subject matter protectable by trade secrets is very large. Exemplary subject matter includes, but is not limited to, compositions and processes to make compositions or devices, devices used to manufacture compositions or other devices, and lists of potential or actual customers or vendors.
So what is a trademark? A trademark is any word, name, symbol, or device that you use or that you intend to use to identify you as the source of the goods or services. Your trademark may be a word, color, or sound that is distinctive enough to identify a source of the goods or services. The policy behind trademarks is to prevent the public from being misled as to the source of the goods and services. Therefore, before adopting a mark as a trademark, you may wish to consider searching marks to see if anyone else is using that mark or similar mark on or in connection with similar goods, so that adoption of your mark does not create consumer confusion as to the source of the goods and services. You can acquire trademark rights through either common law or federal trademark registrations. In the case of common law rights, your trademark rights are based on the first use of your mark in commerce in a particular territory, such as a state or a region. The territorial scope of protection for your mark may be limited to the territory in which you actually use the mark. So if you only use the mark within a state, your protection may be limited to that state. Others may use the same mark in other territories. The SM or TM symbols can be used to designate your common law marks. You do not need a federal application or registration to use the SM or TM symbols. As soon as you are comfortable using the mark as a trademark, you can start using the SM and TM symbols. For federally registered trademarks, you must file an application and obtain a registration. Your application can be based on either use or an intent to use the mark, but to obtain registration, you must establish use of the mark in interstate commerce. A benefit of having federal registration is that the territory for your exclusive rights is countrywide, so you can prevent others from using the same or confusingly similar marks for the same or similar goods throughout the United States. Other benefits of obtaining federal registration include: your registration provides a constructive notice to the public that you claim ownership in the mark. The registration gives you a legal presumption that you are the owner of the mark. And you can use your federal registration as a basis to obtain registration in other countries. And finally, your registration provides you the ability to file your registration with the U.S. Customs Service to prevent importation of goods or services with confusingly similar marks. As the cost of litigation increases, this may become a more valuable resource for enforcing your trademarks. We've already touched on this a little, but what rights do trademark afford your company? You acquire the right to prevent or stop others from using the same or similar mark in any way that creates a likelihood of confusion as to the source of the goods or services. Note that there does not have to be actual confusion, but merely a likelihood of confusion as to the source of the goods. The term of the trademark is for so long as the mark is used on or in connection with goods or services and can function as a source identifier for those goods or services. Your federal registration requires periodic renewals to maintain the registration. What can you protect with your trademark? The goodwill that you have established with your company. In other words, your good name. And the scope of protection extends to any marks that may cause confusion with the consumer. Turning now to copyrights. A copyright confers certain exclusive rights to any original works of authorship fixed in a tangible medium of expression. Original works of authorships may include product packaging, user instructions, software, training manuals, and the like. To obtain copyright protection, the work must be original. This doesn't mean that the work need be completely original, but it must be more than a mere trivial deviation from another work to be considered original. The material must be a work of authorship. This means that some creativity is required, so things like ideas, procedures, processes, systems, methods of operation, concepts, principles, and discoveries are excluded from copyright protection. Fixed in a tangible medium means that the work of authorship is somehow memorialized. The work could be fixed on a piece of paper, a CD, a computer hard disk, or even in computer memory. It may be easy to remember what copyrights protect by remembering the policy behind copyrights, which is to encourage the expression of original artistic ideas into a tangible medium by providing exclusive rights to such works. When you own a copyright, you have an exclusive right to make and distribute copies of the work, to make derivative works, that is, to take the original work and make modifications of the original work, and to perform or publicly display the work. Now, you may have heard of an exception to these exclusive rights called the fair use exception. The fair use exception allows others to copy your materials or you to copy others' materials for limited uses such as teaching, research, criticism, and comment. The term of a copyright is quite long. In the case of an individual author, the term is life plus 70 years. And in the case of works prepared by a company, the term is 95 years from first publication or 120 years from its creation. So thinking again about your company, what might be copyrightable? Any manuals, instructions, user guides, packaging, or forms that you put together. Any software code, papers, presentations, and your website content. Often you want to ensure that you and not a contractor has copyrights in the materials that you use for your company. Not all copyrights automatically vest with a company, so make sure you have proper paperwork in place to ensure that you obtain the copyrights for materials that you paid to have created. If you do have a copyright, you should give notice of that right by placing a copyright symbol, your name, and the year of the copyright. You do not have to register your work before you place a copyright symbol on the work. As soon as the work is fixed, you can use the copyright symbol to indicate your rights in the work.
So now that Cindy and I have discussed the 4 primary areas of intellectual property, how should you go about identifying your company's intellectual property? To begin, you might inventory what your company already has. More specifically, what technology may be suitable for patent or trade secret protection? Might trademark protection be a possibility for your company's name, a company slogan, or a tagline, or even your company's products or services? And are there any materials suitable for copyright protection? You might consider, for example, your company's marketing materials, and you might also consider any proprietary source code used in software. Now, having identified your company's intellectual property, what might you consider in determining how to best protect it? As it relates to an invention, a fundamental question might be whether to seek patent protection or maintain it as a trade secret. In making this determination, consider how easily the invention can be reverse engineered. Remember that there is no trade secret misappropriation if the invention was independently derived or acquired through lawful means, including reverse engineering. You may also want to consider whether the invention is novel and non-obvious, that is, whether the invention meets the high standards for patentability. Also, consider how easily infringement could be detected. And it would also be prudent to consider the lifetime of an invention. Obtaining a patent can easily take more than 3 years, and the term of a patent, again, is 20 years. Therefore, if the lifetime of the invention is less than 3 years or greater than 20 years, and the invention cannot be reverse engineered, maintaining it a trade secret may make some sense. Had a patent application for the Coke recipe been filed in the late 1800s, any resulting patent would have long since expired, and the Coke recipe today would be in the public domain, free for all and reserved exclusively to none. Finally, consider the relatively low costs of maintaining a trade secret versus the relatively high costs of obtaining and enforcing a patent. And in terms of trademarks, one important decision is whether to rely on common law trademark rights or seek federal trademark protection. In making this decision, consider whether your company is currently using the mark or has an intent to use the mark in the future. Consider also how distinctive the mark is. Importantly, you may also want to consider whether others are using the same or a similar mark for the same or similar goods or services. And as for copyrights, well, consider whether your company's original works of authorship comprise at least the modicum of creativity that is required for copyright protection. Consider also whether your company is the owner of the works. For all intellectual property, you may consider a couple additional things. One, whether your company will likely enforce its intellectual property. Two, whether it may be important, for example, to investors to have company assets. You may also consider which jurisdictions your company will be doing business in, and also consider how much your company can afford to identify and protect its intellectual property. Now, in terms of taking actual steps to protect your company's inventions for patents, we recommend making sure to file applications within the appropriate time frame before any bar dates. You should also use confidentiality or non-disclosure agreements to limit public disclosure of your invention to third parties prior to filing patent applications. Use employment agreements and assignments and other agreements to procure your rights from employees and contractors. Now, with regard to your company's trade secrets, we recommend cataloging your trade secrets. Understand what you have. Use proprietary notices on documents. Use confidentiality or non-disclosure agreements again when working with third parties. And last, restrict access to trade secret information even among employees. For example, employees may only have access to their respective proprietary sub-processes, but not to the overall proprietary process.
So what can you do to protect your trademark rights? First, pick a term or symbol that is distinctive and that can be used to identify your goods and services. We often have to fight with marketing and salespeople because they want to protect marks that are generic or descriptive of the goods or services. Remember, the term or symbol must be distinctive enough to enable someone to identify the source of the goods or services. Then considering policing your mark to see if anyone else is trying to cash in on your goodwill by using the same or confusingly similar mark to yours. As previously noted, not all IP rights vest in a company merely because your company paid someone to create the IP. So to protect your company's rights, you should address IP ownership in employment agreements that new or existing employees sign, consulting or contractor agreements, supply agreements that you have with your vendors, joint development, collaboration, and sponsored research agreements, and of course, license agreements. In addition, you should educate your employees on the importance of IP and how it adds value to your company, how to create, identify, and protect intellectual property by, for example, keeping notebooks, using non-disclosure agreements, and having any agreement reviewed by appropriate personnel before it gets signed, and how to respect others' intellectual property and mitigate the chance of infringing others' IP before you get too far down the road. How can you avoid infringement of others' IP? With regards to patents, you can commission clearance or freedom to operate searches. You may consider doing this before you've invested too much money in technology to give your company an opportunity to design around any potentially problematic patents. For trade secrets, you can talk to your employees to let them know you respect the IP of others and to not seek or share anything that might be a trade secret of someone else. For trademarks, we typically recommend searching to see if the mark that you want to use is available. Also, if you won't be using the mark for a while, you may consider filing an intent to use trademark application. This allows the Trademark Office to investigate whether there are any similar marks. Finally, for copyrights, you can educate your employees on the proper use of others' copyrighted material. Make sure that your employees understand any license agreements that you may have with any of your software providers.
Now, as you consider the suggestions for identifying and protecting intellectual property that Cindy and I have provided, here are a few resources that may be helpful for you. Google, the United States Patent and Trademark Office, and the World Intellectual Property Organization each have databases to search for patents and published patent applications. The USPTO and the World Intellectual Property Organization also have comprehensive databases to search for trademarks. Now, as you evaluate your company's intellectual property, you should also be on the lookout for developments in the landscape of intellectual property law. For example, on September 16, 2011, President Barack Obama signed into law the America Invents Act. The U.S. will now have a first-to-file system for patent applications filed on or after March 16, 2013, and this may especially impact startup companies like yours. It is expected that the FDA will be releasing regulatory guidelines for biosimilar compounds in the near future. And there's also the case of Myriad Genetics. The Supreme Court of the U.S. may be involved in deciding whether patents on the BRCA1 or BRCA2 genes associated with breast and ovarian cancer are invalid as not being made by man.
In this workshop, we hope to have provided to you an overview of intellectual property, a discussion of various forms of intellectual property rights, tools to create a plan to identify and protect your intellectual property, and mechanisms to avoid the thicket of third-party intellectual property, and finally, to add value to your company by identifying, creating, and protecting your intellectual property. Now, as part of this workshop, we have an assignment for you. To understand the IP that your company may already have, we're asking you to audit and inventory your existing intellectual property by looking for technology that may be appropriate for consideration of possible additional patent or trade secret protection, brands, marks, and logos for possible trademark protection, and documents and website material for possible copyright material. And then work with your incubator team or mentors to identify the next steps in creating an intellectual property protection plan for your company.
Cindy, Bill, and I appreciate you joining us and hope you have found the information that we presented useful. If you have any questions regarding this presentation, or if we can be of any assistance in identifying and protecting your company's intellectual property, please don't hesitate to contact us at the numbers and email addresses provided. We look forward to possibly working with you, and we truly wish you the best of success in your business ventures.